This video is to help you understand your legal rights on licence and what happens if you are recalled. The information applies to those serving a standard determinate sentence.
Before you are released, the prison will give you a copy of your licence to sign. Even if you do not sign it, the licence will still apply.
Licence is an important part of your sentence and should be taken seriously. You will remain on licence until your sentence end date. Your licence has a set of standard conditions everyone has to follow. They are: be well behaved, not commit criminal offences, attend meetings with YOTO probation, live where YOTO probation says, get approval for a job, not travel outside the UK, tell YOTO probation if you use a different name, even on social media, tell YOTO probation if you change your contact details.
Your licence may also have extra conditions like electronic monitoring, curfews, non-contact orders, exclusion zones, only having one mobile phone, alcohol or drug testing.
The law says licence conditions must be proportionate, reasonable and necessary to manage your risk. If you are unhappy with your extra conditions, you can ask YOTO probation to review them or get legal advice to see if they can be challenged.
Your licence will be monitored by YOTO probation. If you break any of the conditions, even once, you are in breach of your licence. For example, if you stay overnight at a friend's house when you are meant to be living at an approved premises.
Breaching your licence means YOTO probation can ask the Secretary of State to recall you. Recall means that you return immediately to prison. You will not go to court first.
Youth offending team or probation can recall you even if they only think you may have broken your licence. They do not need to prove it. For example, if you are arrested but the offence is still under investigation. Once you have been recalled, you need to find out if you have received a fixed term recall or a standard recall. Your prison offender manager or resettlement worker should be able to tell you. The information will also be in your recall dossier, a pack of paperwork about you and why you have been recalled.
If you have a fixed term recall, you will be automatically re-released after 14 days if your sentence was less than 12 months, or 28 days if your sentence was 12 months or more.
If you are recalled during your early release or HDC period, and only for breach of your tag or early release curfew, you will be automatically re-released at your conditional release date, the date you would have been released if you had not got out early.
It is more common to have a standard term recall. This means you will not be automatically re-released until your sentence end date. To get out earlier, you must prove that your risk of serious harm is manageable in the community. The Secretary of State can direct executive release, or you can apply to the Parole Board for release through the parole process. The Parole Board is an independent body who will decide if you can be re-released by looking at your risk factors and the risk management plan. The Parole Board will look at your case in several stages. The first is a paper review, which happens 4 to 6 weeks after you are recalled. This is sometimes called the 28-day review. If they do not release you after looking at your papers, your case can go to a second stage called an oral hearing, where you and other professionals meet with the Parole Board in person or by video link to talk through your recall. If you are re-released ahead of your sentence end date, you will be back on licence under the supervision of YOTO probation until the end of your sentence.
Securing re-release after recall is complicated. You should contact a solicitor straight away to help you. If you are financially eligible, there is legal aid available for all stages of the recall process.